So this is a cop in Illinois. He says, my agency recently began an unwritten policy around parole searches. They are saying we need to ask permission to conduct a parole search. Josh, do you have the case on this, Josh? From my buddy from, is Josh here, Illinois? Um, okay, so Josh, anyway, if he's here, he may have the case on this, but permission to conduct a parole search from a person that's on parole, meaning, okay, we want consent search. If they do not consent, or refuse to allow us to do it, they said just release them and call their parole officer. Okay, well, that's not the law in Illinois. Okay, so I guess Josh is not here, but I'm going to tell you what the case is. I meant to pull this up before we got going, but I just didn't have time. So let me just pull up Illinois real quick.
So we're talking about a Fourth Amendment waiver? Is that what we're talking about? Oh, okay. But asking them if we can search them under it? Interesting.
Yeah. So look, so he's on a, but I think here's the problem though. Like, so what's the rules of engagement? Okay. Under the Supreme Court case, Sampson and court cases, Sampson and Knight, the U.S. Supreme Court basically laid out the framework for parole searches, but they have, they have been applied to probation as well. But basically what the Supreme Court said that, parole is another form of custody in a sense. It's like, yeah, you're still serving your time, but you're going to serve it in the community.
Right.
Therefore, there's a very compelling penological interest to conduct these warrantless searches. I shouldn't say warrantless searches. It's even better. Suspicionless searches. That's the key here. Sampson says that we can conduct suspicionless searches under just because they're on a Fourth Amendment waiver, right? Okay. Now, not every state is strictly a Sampson style state. I mean, California is, and I got to tell you, I'll tell you, I didn't think any other state was more. I'm not aware of any other state that was as far reaching as California, that they can just, stop people and do suspicional searches as long as it's not arbitrary, capricious, or harassing. But come to find out, Illinois is one of those states that doesn't require reasonable suspicion, or
no, Nevada's not.
So. Nevada is definitely not. In fact, Nevada is, a little bit more restrictor. He said, look, not only do you need some reason to believe they're violating the terms, that's an NRS, but they also have to be done at the behest, really, of P&P, parole and probation.
Yeah.
Now, police can be the agent of P&P, but they have to kind of start it. Right. So, but not Illinois. According to People versus Wilson, a case from 2008, Illinois Supreme Court. So that's good. They said no reasonable suspicion was required for a warrantless search of a person who was on mandatory supervised release, MSR, and therefore this was a search of their house. So for my my cop in Illinois, that's incorrect. But I'm not your boss. I'm not your legal advisor. If for some reason they don't like it, but if you want to show them some case law, show them People versus Wilson, Supreme Court of Illinois, 2008. All right.